everything goes smoothly. So big welcome to everyone who's joined us today. My name is Gloria Vidovich, and I am the Plan Giving and Donor Relations Officer here at the BTC. It is my pleasure to kick off the third and final webinar in our Plan Giving series. We are joined today by professional advisors Arin Klug, Candice J, and Vlad Solokhine for a thorough presentation on the topic of wills. All three are members with the Canadian Association of Gift Planners and have generously been volunteering with charities to help build awareness among Canadians on charitable gift planning, including gifts and wills. For those joining us today who are new to the Bruce Trail Conservancy, welcome. A little bit about us. We are one of Ontario's largest land trusts. Our vision is to secure a permanently protected natural corridor along the Niagara Escarpment. We are doing this by purchasing land from Niagara to Tobermory and making it permanently accessible by way of the Bruce Trail. The trail is close to 900 kilometers long, and 68.9% of it is permanently secured thanks to the support of our donors. Gifts and wills are powerful gifts that help to ensure our work continues well into the future and that future generations will have access to this beautiful treasure. I have the pleasure of introducing today's presenters, and I will start with Arin Klug. Arin is the co-founder and chief operating officer of Epilogue Wills, an online platform that helps people create their own wills and other estate planning documents like powers of attorney. Before starting Epilogue, Arin practiced as a tax and estate planning lawyer in Toronto, where he saw firsthand how factors like time and cost prevented people from completing the will-making process. With a background in computer science, Arin believed that he could use technology to address this problem. He teamed up with another estate planning lawyer, and the two of them started Epilogue with the goal of democratizing the planning process. Next, we have Candice J. Candice has over 15 years of experience in the financial industry and is a vice president at CC&L Private Capital. Her practice guides and works with charitable foundations and high net worth clients to achieve their unique financial goals and strategies. Strategic philanthropy is also an important part of Candice's client conversations, and she is passionate about helping clients identify values and areas where philanthropy can play a role. She has extensive experience helping environmental, healthcare, and arts charities and guides her family's legacy giving to all causes near and dear to them. And finally, we have Vlad Solokhine. Vlad is a certified financial planner with over 15 years of experience in the financial services industry. He is a team member at the Lazar-Wealth Succession Strategies, a financial planning boutique. Before starting his own financial planning practice in 2012, he had the privilege to work in a major Canadian bank, an insurance company, and a mutual funds company in advisory and senior management roles. In his practice, Vlad specializes in philanthropy planning, helping people with disabilities, and people in career transition. We have a lot of experience around the table today. So excited to be doing this with all of you, and Candice will be facilitating today's presentation. Over to you, Candice.
Thank you, Gloria, and thank you for having us. We are so excited to be here today to talk about wills, estate planning, and lots of other things. So please keep your questions coming through the Q&A chat box, and I'll be moderating our conversation today with Arin and Vlad. But first, we wanted to start off with a little background on wills in Canada. And you may have started to notice a national campaign called Willpower. And this campaign is led by the Canadian Association of Gift Planners Foundation and a national public education effort designed to inspire more Canadians to make a significant impact on the causes that they care about, with a gift in their will to charities that are near and dear to them. So over 50% of Canadians do not have a will. And there has been a lot of conversation to encourage Canadians to create, to update, and to leave a charitable gift in their will. And Bruce Trail Conservancy is also a partner of the campaign and a listed charity. And given that Vlad, Arin, and I are all founding partners of the Willpower campaign, and Vlad and I are listed as professional advisors on the site, and Epilogue is listed as an online will service provider for the campaign, we wanted to touch on it a little bit more today. So we know from studies that only 5% of Canadians leave a gift in their will. And with the Willpower campaign, the long-term goal is to have 8.5% of Canadians leave a gift in their will by 2030. And I know that sounds like a long time and a really small 3.5% increase, but that small increase will generate $40 billion to charities. So remember, you don't need to only choose family or charity. You can choose both. And even better, use some of the strategic charitable giving techniques we will touch on today to help your estate plan and reduce down the tax burden for your loved ones. Visit www.willpower.ca for more information. It's a very easy website to use and has a lot of free resources on there. So start your conversation today with your charity professional like Gloria and us as your trusted advisors, and make sure everyone works collaboratively together to make sure your estate is planned out purposefully. Now, first, I wanted to start with a question for both of you, Arin and Vlad. Have you seen an increase or shift in the trends in estate planning and will creation? And let's start with you, Arin.
Sure. Thanks, Candice, and thanks everyone for having me today. One of the things I've noticed, especially over the last couple of years with the pandemic, is people turning their minds more to their digital assets. And so it used to be the case that, your assets were all physical. You had a physical bank account, you had a physical home, everything you could see and touch. But right now, that's not the case anymore. People have their photos not in photo albums, they have them in their iCloud accounts. And these are things that until recently, people weren't turning their minds to when it came to estate planning. They used to say as an executor, you could just sort of wait by the deceased mailbox and get all their bills and get all their bank statements and know what obligations they have and what they own. It's not the case anymore. Even our bank statements are digital now, right? And so it's so important for people to think about those aspects too when they're doing their estate planning. And the pandemic has gotten people to thinking more about their digital assets in addition to their physical assets.
Thank you, Arin. Vlad, your comments.
Thank you, Candice. Yes, definitely. I noticed that in my practice, people started thinking more about estate planning, creating a will, but I noticed that it was more of a snowball in the beginning of the pandemic. And then it interestingly progressed further. People started thinking, okay, yes, maybe it's inevitable that at one point I leave this world, but what happened next? How do I make sure that everything that I worked on will be passed to someone and it's meaningful? It's not just, that fear of inevitable that probably sparked in the beginning of the pandemic. It's that evolution of people thinking further, starting planning their wills, their bequests, and so on and so forth. That's definitely the trend right now.
Thank you both. And I completely agree. The pandemic has definitely brought mortality and planning conversations to the forefront, and integrating it with will writing or updates. Clients are coming to me too, saying either they've already updated their will or they're in the process of updating their wills and wanted to talk about investment planning in conjunction with their will planning. So now I'd like to turn it to Arin to give our audience a little more background on wills, and we'll start with a bit of a wills 101.
Great. So yeah, I know, people come into talks like this with different levels of knowledge about estate planning. Some people know a lot, some people know very little. So we figured a good way to start was with sort of a basics of will planning, just to sort of catch everybody up to speed. So, a will basically is a set of instructions that somebody leaves while they're alive that get implemented after they pass away. And there's a few basic elements that go into pretty much every will, and I want to talk about them. So the first thing that goes into a will is appointing an executor. All right, so after somebody passes away, somebody else has to be there to start to wind things up and manage their affairs. And so, one of the things that they need to do is make funeral and burial arrangements, figuring out what the person owned. And like I mentioned earlier, that's getting harder and harder. The executor's job is to figure out what the person actually owned. Arrangements have to be made for paying debts and filing and paying taxes. You have tax obligations after you pass away. The executor's job is to manage those as well. They have to close down bank accounts, utility accounts, open up estate accounts, ultimately be responsible for the administration and management of the estate, and ultimately carrying out the wishes in the will. So the executor is an important job, and it's a role that's named in the will itself. A second element that goes into not every will, but a lot of wills, is an appointment of guardians for young children. So if people are parents of young children or have guardianship of young children, an important element of their wills is going to be who to name as the guardian for their children in case they're no longer alive. In cases where children have two parents and one of them passes away, the other one continues to be the guardian. So a guardianship clause doesn't have effect in that scenario. But in a case where both parents are no longer alive, the kids need to have somebody appointed as their legal guardian. That's done in the will. Now, it varies from province to province. What's interesting in Ontario is that the guardianship provision in a will in Ontario is valid for 90 days. It's a temporary guardianship. And within the 90 days, the idea is that somebody should be applying to the court for a permanent guardianship. And obviously, the parents expressing their wishes in their wills is going to be a factor that the court takes into consideration when ultimately giving permanent guardianship to somebody. And then finally, the distribution of assets, right? This is the thing people most closely associate with making a will, right? Who's going to get my stuff? It's worth mentioning that not everything that somebody owns actually forms part of their estate. Vlad's going to touch on this a little bit later, but there's things like, registered accounts, or if you own a piece of property or an account in joint ownership with what's called a right of survivorship, and so one of the joint owners passes away, it's the survivor that takes it over. It doesn't actually form part of the estate. But for everything else that does form part of the estate, for example, a bank or investment account that you own solely in your own name, that forms part of your estate, and it's dealt with according to the instructions in the will. Now, the question is, okay, so what happens if somebody doesn't make a will? And Candice, if you move to the next slide, I'm going to speak a little bit about what happens on an intestacy. So when somebody dies without a will, it's referred to as dying intestate. And the things that we already talked about, naming an executor, naming guardians for children, distribution of assets, somebody who dies intestate basically gives up the ability to make those decisions for themselves while they're alive, and it's up to the courts and the default rules of the province where they live to make those decisions for them. So, for example, if no executor is appointed under a will, somebody has to apply to the court. It's a process. It takes time. It costs money. And it's, again, the type of thing that can be avoided if somebody makes a will and names an executor. As far as the distribution of assets goes, in cases where there's no will, each province has a set of default intestacy rules that set out what's going to happen when somebody passes away without a will. And there's a lot of myths and misconceptions around that. I've heard a lot of people say, oh, if you die without a will, all your assets go to the government. That's not true. It's technically possible in a very, very rare scenario, but by and large, that doesn't happen. But each province has a set of rules of, it's a formula basically of who gets what when somebody passes away without a will. And like I said, there's a lot of misconceptions that are very reasonable. So take, for example, somebody that's been married for 40 years and they've got adult children, and they might very reasonably say, oh, I don't have a will, but if I pass away, everything's just going to go to my spouse. In Ontario, that's actually not the case. Ontario's intestacy rules say that if somebody passes away with a spouse and children and without a will, their assets actually get split between the spouse and the kids. Similarly, in a common law scenario, it doesn't matter whether you've been in a common law relationship for 3 years or 30 years. Under Ontario's intestacy rules, a common law partner does not get anything. They'd actually have to make a separate application to court under what's called dependence relief if they're going to get anything out of the estate. So really important to have a will so that you can dictate where your assets go. There's potentially a lot of adverse estate implications for not having a will. Imagine, again, the spouse and children scenario where somebody's kids are really small, right? And their major asset that they owned personally was their home. So now all of a sudden the kids have an ownership interest in the house together with the surviving spouse. How does that work? Does the public guardian and trustee have to get involved? Things can get very complicated. So very important to have a will. There's also some tax implications associated with not having a will. A will is a great opportunity to do some tax planning. We're going to talk about that more a little bit later. But again, those opportunities are lost when somebody doesn't have a will. And then finally, under the intestacy rules of the provinces, there is no provision for charitable gifts. So there's a formula that talks about sort of close family receiving assets, but there's no provision for charities to receive assets. So anybody that does have a donative intent, and we're going to talk throughout this presentation about the benefits of making testamentary bequests to charities, those opportunities are lost when somebody fails to prepare a will. And so one of my take-home messages today is if you don't already have a will, you should get one. And if you know people that don't, and as Candice mentioned, over 50% of Canadian adults don't, you should encourage them to get one as well.
Thank you, Arin. That's a lot of great information for planning your estate and great stories on what happens in different scenarios. There's so many unique scenarios in everyone's lives. So definitely think about them, see like which ones that you fit into. And it's not a cookie cutter scenario for the most part. But so if you don't make a will or keep it updated, it seems like it's going to be a problem. Right now, I would like to turn it over to Vlad to talk about planning your estate outside of your will, as Arin mentioned, as these are types of accounts that can come up in your portfolio and in your overall way of planning your estate, and they need to be addressed separately. So over to you, Vlad.
Thank you, Candice. Definitely. It's a very interesting process that once you start working on your will, once you get deeper and deeper into this, you may start realizing that you want some of your assets to bypass the will, bypass the probate process. And there are different reasons why you would want that. First of all, it's legal expenses. The process of probating a will could be very useful in some cases. It legally solidifies the estate transfer and protects your beneficiaries. However, as any legal process, it has fees associated with it. And for some reason, Ontario probate fees are the highest in the country. Second reason could be a time delay. The process of probating a will takes time. It might range from a couple of months to a year and even longer, depending on the complexity of the will. And all assets, including in the estate, which could be money or real estate properties, will not be available for distribution during that time. And another reason could be privacy. Your will is a public document. Technically speaking, any person related to the estate or not could examine your will. If you wish to distribute some money privately or make private donation, you cannot include it in your will. There are a few ways to make your assets bypass the estate. For example, holding assets in joint ownership is the very well-known and widely used way of achieving just that. However, the courts and the CRA keep imposing limitations to this method. And if you're interested in all pros and cons of the joint ownership with right of survivorship as the estate bypass instrument, please seek legal advice. On this slide, as you can see, I mentioned three classic methods of estate bypass. It's life insurance, registered accounts such as RRSP or RIF, and segregated funds. All these instruments give you an opportunity to appoint a beneficiary who will receive funds directly bypassing your estate. Later in this presentation, I will outline a few examples showing how to apply those instruments to make a strategic charitable donation. And now, I'm happy to switch it back to Candice.
Thank you, Vlad. So you both talked about different types of vehicles that someone may have in their state, like physical items like land, taxable investments, and outside of the state, registered investment portfolios and insurance-based policies. All of these components require a different professional to guide and help you through the original setup and also maintenance of it. And this is why it's extremely important to have a holistic view of your planning and not siloed. And your trusted advisors should really work together to plan out your estate. So I'd like to take a moment now to talk about collaboration. Collaboration is key so that everyone is on the same page, and same goes for your donations now or in the future. And the charity should be aware so that they can recognize you and thank you, but also make sure your wishes are fulfilled. So on the screen, you can see on the circle, there's different philanthropic strategies. All of them can work separately, but they can be more powerful when thought of together, so you have the most efficient outcome of converting your taxable situations into charitable giving instead. And you may recognize some of these independent strategies, and you may already use some of them. And in the first part of our 3-part webinar series, we had shown an example of the different impact and effect of making direct gifts to charities through what many advisors call checkbook philanthropy, which means giving in cash directly or giving through your credit card or through monthly mailing campaigns versus donating stocks with a high capital gain from your taxable account. That can give you a double benefit in not needing to pay capital gains tax, but you also receive a donation receipt for the entire donated value. Arin will touch on this a little bit later as well. And Vlad just talked about naming charities as a registered account beneficiary or contingent beneficiary, and he will talk further on donating life insurance later on. We had another fabulous webinar with the BTC and their VP of Land Acquisitions on the donation of land. And that was just the second one of our 3-part series, available on the BTC website for a replay. And we had also touched on donor advised funds in the first part of the 3-part webinar series. So today we're focusing on charitable giving in wills and estate planning. We're seeing a growing number of professional advisors, accountants, lawyers, and financial professionals who are becoming very well versed in this area. But to make it even simpler for our audience, the Willpower website has gathered a comprehensive list of professional advisors with a philanthropic practice that are listed on the website itself. So make sure you speak with the wonderful charity professionals like Gloria at the BTC, as they have a wealth of knowledge and can help out and introduce philanthropic strategies and advisors to help maximize your estate and philanthropic planning. So Arin, at this time, I'd like to talk a bit more about charitable bequests. Can you expand on gifting in your will?
Absolutely. So before I dive into gifting in wills specifically, I think it's worth giving a little bit of background on how a will is structured and why, and it'll give some context to what we're going to talk about. So, some people think when they make their will, they have to basically include in the document a list of everything they own, right? And say who it's going to go to. That's actually not the way wills work, and there's a couple of reasons for it. The first one is it's not practical. Right? It's a process of, updating your will. And if you had to update your will every time you acquired a new asset or you disposed of an asset, again, it's just not practical. So that's one reason why we don't list things in a will. The second reason, and Vlad touched on this a little bit earlier, is that a will, once it's probated, becomes a public document. And so when somebody passes away, they might have a will and the executor might have executor named in the will. But if the executor walks into a bank, for example, with a copy of the will and a copy of the death certificate, the bank's not just going to give that person access to the deceased's account. The bank's not going to accept that liability. So there's a process called probate, where a court in the province sort of verifies the will. They actually put a seal on the will as the last will and testament of the person. And that probate certificate that the executor has gives them the ability to then walk into the bank and get access to the accounts. But when a will goes through probate, that's when it turns into a public document. Like Vlad said, anybody, whether they're related to the estate or not, can see that document. So that's another reason why you would not want to list all of your assets in your will, because then it becomes public. So what do you do if you don't list all of your assets in your will? So wills talk in relatively general terms. Payment of debts and expenses. You do have the opportunity to identify particular articles. If there's a specific item you want to give to a specific person, give my car to my nephew or my my pocket watch to my cousin, things like that. Monetary gifts as well can be included as specific gifts, $25,000 to a friend or $50,000 to a particular charity. And then everything else that's not specifically identified in the will, that's called the residue. So it's just normally the bulk of the estate. And that's dealt with in general terms, typically as, a percentages, right? Divided equally among my children, or give everything else to my spouse. Everything that I haven't already talked about goes to my spouse. So that's sort of the general scheme of a will. And now we can talk a little bit about how charitable bequests work in wills. One of the things that's really nice about charitable bequests and wills is that they're really flexible. There's a lot of optionality associated with them. So we're going to talk about some of that. The first point is a gift to a charity in a will can be a specific bequest or part of the residue, right? So the examples I gave earlier, you can give that $50,000, you can identify a $50,000 gift to a particular charity as a specific gift that sort of comes off the top, or you can not sort of include it in that list of items, but as part of the residue where you're dividing proportions of your estate among beneficiaries, you could say, I leave 2% of my estate to this particular charity. There's pros and cons to both, right? A specific dollar amount, that's not going to change. But $50,000 on the day you write your will might not be as meaningful as $50,000 when you pass away. When you're leaving a percentage of your estate, that's going to grow as your estate grows. It's going to shrink as your estate shrinks. So again, the quantum of the gift at the end of the day is going to be affected if it's a residue provision, but there's also some certainty in knowing that, X percent is going to charity and Y percent is going to the other beneficiaries. So that's one option. Second option is what the gift is. Right? So all the examples I've given so far, I've talked about gifts of cash, right? $50,000 gift to a charity. But there's nothing stopping somebody from giving a gift of property. And that's particularly important when we're talking about an organization like Bruce Trail Conservancy, which accepts gifts of land. And so somebody can make a gift of land, or you've seen, and I'm sure heard ads for charities that accept cars as gifts, right? Anything can be donated to a charity as long as the charity is willing to accept it. One of the things that we'll talk about a little bit later is the benefits of donating securities, marketable securities, publicly traded shares to a charity. But those are called gifts in kind, and they're different from gifts in cash. Now, one of the issues associated with gifts in kind is that unless it's cash or unless it's securities that have a fair market value, there's typically has to be an appraisal done, right? Because the charity issues a tax donation receipt for the donation. And if it's an in-kind gift, there has to be a fair market value attached to that gift. So there's an appraisal process for gifts in kind. The next point that I'll talk about in terms of gifts and wills is whether the gift is a directed gift or an undirected gift, sometimes referred to as a restricted gift or an unrestricted gift. But this is just a question of what the gift is being used for. So the simplest option is to just make the gift, the gift $50,000 or whatever it is to the charity to use and apply in the way that they best see fit or in the area that's of greatest need at the time of my death. Other people like to make sure that the gift is used for a very specific purpose. When I was in practice, I saw a lot of this happen around gifts to hospitals, for example. So if there was a particular, area of the hospital, a particular treatment, sometimes at cancer facility that benefited the person during their lifetime, that was a gift that a person wanted to give, not just to a particular organization, but a particular organization for a particular purpose. That's a directed gift. Directed gifts, if it's something that you'd like to do, it's fantastic. I would encourage you to speak to the charity if you're thinking about making a directed gift, because we don't necessarily always know what the charity's greatest needs are. And we might have in our minds an idea of where we think the gift should be used, where we want it to be used, but that may not necessarily align with the charity's needs, particularly if I'm writing my will today, but I'm not going to pass away for another 40 years. It may not even be possible to predict what the charity's needs are going to be, or whether the program that you've identified in your will is even going to exist in the future. And so, there's definitely an affinity that people have towards making directed gifts and knowing how the gift is going to be applied. But there's a little bit of push and pull in understanding that, the charities ultimately need some flexibility or may need flexibility in terms of how those funds are going to be applied. The last element I'm going to talk about in terms of gifts in wills is the timing of the gift. So, testamentary gifts are so incredible because they give people the opportunity to potentially make a gift that's bigger than any gift they've ever made in their entire lives, right? Think about a situation in which, a couple, neither one is alive, it's the second death, the house is being sold, their largest asset. So, there's potential living in most, urban centers in Canada these days for six-figure gifts to come out of home sales, right? And again, this is a situation where people feel comfortable to make that gift, and they've had those conversations with the charities. But, that big six-figure gift may not be a gift that can be made when the first spouse passes away, right? Because the second spouse still has to live in the house. So there may not be enough comfort to make that kind of testamentary gift on the first death. But as a conversation, between partners and with a charity, you might be able to say, okay, well, but when both of us pass away, we know that our house is going to be sold. All of our kids have their own houses already. And so, we're very happy for a big chunk of the proceeds of that sale to be donated to the charity. So the wills in that sense can be coordinated, where the gift isn't made on the first death, but each will says, okay, if I'm the survivor, and then when I pass away, this is the gift we want to be made. And this is the gift that's going to be made in both of our names. It's a generational gift. It's a family gift. It's not just for me, it's from the two of us. And so, as you can see, there's a lot of flexibility when it comes to making gifts in wills with respect to what you're giving, when you're giving it, what it's going to be used for, and whether it's a specific dollar amount or a percentage of the estate.
Thank you, Arin. I love your comments on restricted and unrestricted gifts. And I see this all the time with my foundation clients, that they have an amount under restricted and the charity can't seem to touch and have access to it because of the nature of it. And I'm sure the intent of the donor wasn't to keep it invested for a long time, but for the charity to use. So I would also caution not to be too restrictive in your directions. And as Arin also said, to have a conversation with the charities that you're leaving the gifts to. And the BTC also receives gifts of land from their supporters. Arin, can you also speak to some experiences you had helping clients with their gifts of land?
Yeah, absolutely. When I was practicing, I didn't see this so much in the testamentary context, but sort of even while people are alive, there's tremendous benefits to giving gifts of land. In fact, the tax regime here is that certain gifts of land, specifically ecologically sensitive lands, can be certified and donated to certain organizations. I believe BTC is one of those organizations that can accept gifts of certified ecologically sensitive lands. And what's really interesting about those gifts is that there's a double benefit. Number one, you get there's actually a triple benefit. Number one, you get the benefit of donating and doing something amazing and benefiting an incredible organization. Number two, there's the tax benefit that you get from the donation credit, right? There's going to be an appraisal of the land. There's a fair market value associated with the land, and you get a donation credit associated with that. The third one, though, is that our tax regime in Canada is that typically if you dispose of an asset that has a gain, whether it's a stock or a piece of land, not your principal residence, but if there's a gain, there's a tax associated with that gain. Gifts of ecologically sensitive land that have been certified, that gain, whatever it is actually exempt from tax. So there's really are tremendous tax benefits to giving those types of gifts to organizations like BTC and other organizations that can accept those types of gifts.
Thank you, Arin. And as I mentioned before, we had a wonderful webinar at the end of 2021 with BTC's VP of Land Acquisitions to talk about this in depth. So don't hesitate to go to the BTC website to view that recording as well. So at this time, Vlad, I would like to turn it to you to now further expand on some of the philanthropic strategies that you help clients with.
Great. Thank you, Candice. And I'd like to start with life insurance. The beauty of this instrument is that it is very familiar, but yet very powerful, so that many people could enhance the impact of their legacy. Let's say that we have a 60-year-old woman who regularly donates $200 a month and every year gets annual charitable receipt for the combined amount of $2,400. Assuming normal longevity, this woman will eventually donate anywhere between $60,000 and $70,000 over her lifetime. However, if that woman buys a life insurance policy, the same $200 a month at the age of 60 could buy her about $104,000 of life insurance coverage that she could donate to any registered charity. As you can see, she doesn't spend a penny more. She doesn't pay any extra setup fees or anything of that matter, and yet sizably increases her charitable gift. Another benefit of donating life insurance policy, it could be done in complete privacy. As I said before, somebody's will is a public document, and life insurance policy does not form the part of the estate. It does not have to be disclosed in the will or anywhere else, and this type of donation could be legally done in complete privacy. Let's move on to the next slide and review the strategies that you could use with your registered savings. Registered savings is just the term that's used for all those accounts that basically start with R, RRSP, RIF, sometimes with L, LIRA, and likewise. And many of you know that there is such a thing as spousal rollover. When first spouse passes away, their RIF or RRSP balance rolls over tax-free to survived spouse. And that is why you should always have your spouse as a primary RIF beneficiary. But what happens when the last spouse or a single person dies? Could the money be rolled over tax-free to their children or grandchildren? Unfortunately, the answer is no. In this case, all remaining balances of their RIF or RRSP are considered to be their taxable income in a single year of death. And it is not unusual for those accounts to have few $100,000 balances. And when all those few hundred thousands become an income in a single year, it triggers marginal tax rate that could go as high as 53%. In other words, more than half of the money could go to the government. And that is why the main idea is not to try and pass your RRSP or RIF money to your heirs. Instead, it makes sense to start thinking about the registered charity like Bruce Trail Conservancy. If you consider leaving some money from your estate to a charity, the money from your RRSP or RIF would be the most natural and most tax-effective way of doing so. And there are three options that you could use. Option number one, most simple but yet very effective, making charity a contingent or secondary beneficiary. By doing so, you and your spouse make sure that, first of all, if either one of you passes away, the surviving spouse receives the balance tax-free with spousal rollover. But secondly, when the last spouse dies, it's the charity that receives the remaining RIF balance. And it's a great option for those who want the leftovers of their RIF donated to charity entirely. But what if you want to achieve some balance and make sure that your children and grandchildren also receive some money? Well, then we move on to option number two. First of all, you do the same thing. You designate the charity as a contingent beneficiary on your RIF, and it saves you a sizable amount of money in taxes. And using just a fraction of that money, you buy a life insurance policy and designate your children or grandchildren as the beneficiaries. So when the last spouse dies, children receive the life insurance payout tax-free, and the charity receives the remaining RIF balance, issues a corresponding tax receipt, so that the state will not pay any RIF taxes. This option requires understanding of technical aspects and some financial planning research. So please make sure that you seek professional advice if you'd like to proceed with it. And option number three. Let's say that your children and grandchildren inherit the house, the cottage, some other assets, so that you want the charity to get the whole RIF balance. And if you use the option number one and simply assign the charity as a contingent beneficiary, it's good enough. But you still could increase that gift without adding any extra money, simply by using the power of life insurance. You simply buy a life insurance policy, assign it to your favorite charity, and pay the premiums on this policy using your RIF withdrawals. Under normal circumstances, RIF withdrawals are taxable. However, the registered charity will issue corresponding tax receipts that will offset the taxes. And in many cases, tax break could be even higher than the required tax payment. So you might even receive additional tax break. It might sound a bit complicated, but believe me, the efficiency, the tax efficiency of it is worth it. And now let's review the last estate bypass instrument, which is the segregated funds on the next slide. The segregated funds are very similar to other investment funds that you might be familiar with, such as mutual funds and ETFs. What makes segregated funds unique is their insurance nature. Legally, a segregated fund is an insurance contract. And that means that they have a few features that could be extremely helpful in the estate planning process. In that context, whether you think about transferring your money to a person or donating it to a charity, segregated funds have features that are usually associated with life insurance, but now could be applied to actual liquid money. Even though segregated funds investments moves up and down with the market, just like regular mutual funds, it has principal guarantees. In other words, if you're thinking about donating a sum of money to a charity, you could be sure that your donation will never go below the invested principal, even though your money is fully invested and go up and down. Since segregated funds are insurance contracts, they bypass the estate. It means that there will be no time delays, no probate fees, and no creditor claims. Segregated funds are probably the only financial instruments that allows you to name a beneficiary on a regular, non-registered money, which is not part of your RRSP or tax-free savings account. That creates additional advantage for those who need it. The transfer of money or charitable donation could be done in complete privacy. By the way, on any segregated fund contract, you could assign as many beneficiaries as you want, and your favorite charity could be just one of them. Simply specify the percentage for every beneficiary, and your wish will be fulfilled quickly and efficiently. With that in mind, I'm happy to pass it over to Candice.
Thank you, Vlad. Now I'd like to pass it back to Arin to talk about death and taxes.
Thanks, Candice. And it's a big subject, death and taxes. I'm going to try to cover it as succinctly as I can because I want to leave some time for some questions, which I'm sure we're going to have. So I touched on this a little bit earlier when I was talking about the capital gain, right? If you buy something and then it appreciates in value and then you sell it down the road, there's what's called a capital gain in value of the property or the assets, and there's tax associated with that, right? Again, it doesn't apply to principal residence, but most other capital property it does. When somebody dies in Canada, the tax laws are such that there's a deemed disposition of all their capital property, which means that, let's say if you own a stock portfolio, when you pass away, you haven't sold that stock portfolio, but for income tax purposes in Canada, it's as if you've sold it. That tax is payable, even though you haven't actually sold it. So when in the year that people pass away, they often have more tax to pay than they ever had in their entire lives, which is why I like to say that in the year you pass away, you get the biggest tax bill that you're never actually going to see. You don't see it, you're not around, but it's still a very large bill, and it's your executor and it's your family members that have to deal with it. And there are a lot of great strategies that have developed to help deal with this tax event that happens when somebody passes away. So one of them is a spousal rollover. Somebody passes away, any property that goes to their spouse, either outright or through a vehicle called the spousal trust, is not subject to the deemed disposition. It's not subject to that capital gain. The gain is actually deferred until the spouse passes away. Once it moves down to the next generation, you have to pay the tax. But giving assets to a spouse is a good way to defer the tax. And based on the example I mentioned earlier, somebody with a spouse and kids, they need to have that will in order to do it. Otherwise, some assets end up at the next generation prematurely. Other ways that people can help mitigate the impact of the deemed disposition, things like estate freezes, buying insurance to cover a portion of the expected tax bill. And this all speaks to sort of the holistic planning that Candice was talking about earlier, making sure that these things are coordinated with your advisors. But another really great way to help mitigate the impact of the tax associated with the deemed disposition is through donation. And we've talked a lot today about the different ways that somebody can do that. Because, and this is really core to the messaging of the Willpower campaign, when you make a donation in your will, when you make a testamentary bequest to charity, it's not, a dollar that's being taken away from your family and being given to the charity, but there's an element of tax savings associated with that, because your estate gets a donation tax credit for the donation that it makes to the estate. And Canada's tax laws around charitable giving changed drastically in 2016 that made giving to charities through your will much more flexible, and it gives your executor a lot of ability to minimize taxes. Somebody in the top marginal tax rate in Ontario making a donation to charity will get a tax receipt that'll save them about 50 cents on the dollar in taxes. And so it's not the case that everything that's going to charity is going away from your family. There's actually the ability to pay less tax, which I think, would be welcoming for everybody. Touched on this earlier a little bit when I was talking about land, but it's also the case for publicly traded securities. That capital gain that's associated with that land or with those securities, when those are donated through a will, the gain becomes zero. So any tax that would have been payable if those things weren't donated isn't payable, number one. And number two, like I mentioned earlier, you also get the tax benefit of the credit associated with those things. So it's really a double bonus, or double, ability to save tax in two different ways when you're making those kinds of donations.
Thank you, Arin. There's just so many ways to redirect taxes to charity, really. So you have to pay it in some way or form, but to be able to redirect it to the causes that you care about, it's so impactful. So, Arin, passing it back to you to round off your section.
Right. Yeah, I thought, I'd talk a little bit about Epilogue, because when most people think about making a will, they think about finding a lawyer, making an appointment with that lawyer, going down to the lawyer's office, telling this person who they may or may not have known before about their personal lives, their family relationships, everything they own, having the lawyer, draft the will. And the stats bear it out. This is an uncomfortable thing for people to do. Like I always said, if you were going to build a task that was like perfect for procrastination, it would be making a will, right? Because people think of it as time consuming, costly, uncomfortable, often not urgent, something they don't really understand, right? Like this is what people procrastinate on. And Candice, you said it earlier, over 50% of Canadians don't have a will. So with my background in tech, with my background in law, and with the knowledge that no lawyer starts to draft a will from a blank sheet of paper, right? This is a templated activity. And one of the things I noticed in my practice is that people that have relatively similar family situations generally want to accomplish the same things when it comes to their wills. So I saw this as a perfect opportunity to be able to automate this process. So me and my co-founder, we created an online platform that helps people with basic planning needs create wills for themselves online. You actually don't need a lawyer to draft a will. That's another misconception around estate planning. The lawyer doesn't have to draft the will. The lawyer doesn't have to witness the will or certify the will or stamp the will or anything like that. It's perfectly legal in every province to make a will on your own, as long as it's signed in accordance with the rules of the province. Typically, that means two witnesses who aren't beneficiaries under the will, being in the same physical location as you, witnessing you sign the will, they each sign the will as you witness, and that's a valid will in most provinces. And so for somebody who's got very basic planning needs and doesn't require legal advice for any complexities associated with their estate, often good for young families whose assets are relatively basic and whose needs are relatively basic. We created an online solution that lets somebody go through our process in about 20 minutes and actually create their own wills, other estate planning documents like powers of attorney, and each document comes with a full set of signing instructions so that the individual can make sure that they're signing these documents and making them valid in accordance with the specific rules of the province where they live.
Thank you, Arin. Now, I would like to wrap this conversation up with one piece of advice that you want to leave our audience today. Before we begin our Q&A, we do have some, so keep this brief, a minute long. Vlad, why don't we start with you on your final piece of advice?
Okay, great. Thank you, Candice. Well, I would say if it's just one thing, engage in estate planning process. Writing a will is a very important step in finalizing legalities of the estate transfer. But the way how you prepare your estate to that moment could make a sizable difference in the amounts that your beneficiaries, that your family members or charities will receive. The earlier you start, the higher positive impact you could achieve.
Thank you, Vlad. And Arin.
One thing I'd like to say is, obviously, like I said before, if you don't have a will or any of the planning in place, it's an important thing to do. But even if you have, it's important to have conversations around it. Nobody likes to get that call out of the blue that says, somebody passed away and you've been named the executor of their estate. Or even worse, you've been named as the guardian of their minor children. Right. And so if you're engaging in the process, part of that process is having conversations with the people that you're assigning to these key roles to make sure, number one, that they're okay with it, they're comfortable with it. Number two, that they understand what the role is. And number three, obviously, that they know that it's going to happen. Right.
Thank you, Arin. And my piece of advice would be to start planning now and to take action now. And it really took a pandemic to help some of the families get going. And I see the planning happen as a consequence of a health caveat. It can be hard to have family conversations at that time or to resolve some of the family miscommunication as well. So you want to be clear on your intentions early and not just verbally, but to have them written down and known to everyone. And your estate will be much more smooth and seamless when your family can be focused on fulfilling your legacy plans instead of fighting about them. So at this time, we wrap up our formal section. I'd like to pass it over to Gloria now to moderate the Q&A. And I know we have some coming in, so over to you, Gloria.